Bonsoir à tous et soyez les bienvenus à ce 8e CoopCongo dialogue. Nous remercions Miss Lucie Njeka pour avoir accepté d'être notre modérateur de ce soir. Sur C, merci d'être venu et Lucie, à vous la parole. Merci, bonsoir.
Merci beaucoup, Papa Marc. Vous allez m'excuser, je m'exprime un peu mieux en anglais, alors I'm going to lead this a bit more in English than in French. So tonight, the topic that we will be discussing is matrimonial regimes. So the financial implications on matrimonial regimes. And to give us more information on that this evening, we have a very good friend of mine, a wonderful lawyer. His name is Kipa. And he will just give us, a few pointers, give us advice. And we will then have a session towards the end for questions. So if you do have questions that you do want to ask over audio, then you can ask towards the end. But if you do have any other questions and you don't want to speak over audio, then you can put your questions in the chat function. And with that being said, I'd like to hand over to Caleb. Caleb, welcome, and you may proceed.
Thank you very much, Lucy, for the warm welcome. Just want to check, can everybody hear me?
Yes, we do.
Okay, cool. Thank you.
We can hear you.
Good evening, everyone. As Lucy stated, I am Caleb Kipa. I am a lawyer by profession, and I have been in practice for 4 years, graduated cum laude from the University of Johannesburg. Also have a BCom law degree, and I graduated top of my class. And I'm proud to say that I'm a young man that's well representing the Congolese community in a predominantly South African and white corporate environment. Before I begin, I would like to just mention that my presentation will be in English, but feel free to stop me along the way should you require me to explain any of the concepts that I will be illustrating. Feel free to ask your questions in French, and if I am not clear, then Lucy will interpret for me, and she'll also interpret my responses. So what I'm going to do now is I'm going to share my screen with everyone because I presented a set of slides. All right, can everyone see my screen?
Yes, we can.
All right, good. All right, so as stated, we're going to be discussing matrimonial property regimes in South Africa. You'll note that a lot of the property regimes around the world are very similar, but the focus will be on South Africa. And then if you've had any other questions, we shall deal with them. So as a quick introduction, many couples, when they enter into this journey of marriage, the focus is on making sure that the wedding day is very pleasurable, is to make sure that it's stress-free, is to make the couples focus on the actual wedding day. But a lot of couples disregard the importance of deciding on a matrimonial property regime that will govern their marriage. And the unfortunate reality is that in South Africa and in most developed countries around the world, that there are many marriages that end up in divorce. And with that being said, it is very important to almost anticipate the end. Obviously, we don't want to get married with the idea of divorce behind, but it's always better to be safer than sorry because the statistics are there, and it's always good to make sure that you're covered financially and that you've chosen the best option. So in South Africa, we have 3 different types of matrimonial property regimes. The first is a marriage in community of property. The second is a marriage out of community of property with the accrual. And the third is the marriage out of community of property without the accrual. The legislation that is governing marriages in South Africa is the Matrimonial Property Act 88 of 1984. So what I'm going to do is I'm going to be discussing the 3 different matrimonial property regimes. And then at the end, I will give advantages and disadvantages. And then we can have questions and answers. So the first one we're looking at is marriage in community of property. This regime is the most popular and most common regime. It is also the default position. This is the regime where no antenuptial contract is entered into. And this is the regime whereby the husband and the wife join each other's assets and estates and become one joint estate. So the husband, whatever assets he had before the marriage and whatever assets he has during the marriage, he shares that with the wife. The same applies for the wife. Whatever assets the wife had before the marriage, whatever assets she acquires during the marriage will form part of a joint estate, one joint estate, and the husband will have a 50% share of those assets. So what happens is that there's the implication of this means that if one spouse runs into debt, so for example, if the husband has a debt with Absa Bank and the husband is not able to pay the debt with Absa Bank, then Absa Bank can go after the wife to claim the debt because they have one joint estate. They are seen as one body. What happens to the husband affects the wife, and what happens to the wife affects the husband. So there are certain exceptions. There are certain acts that, because a husband and wife become one under this matrimonial regime, it means that they must move as one, which also means that the husband cannot enter into certain agreements without the consent of his wife. And the wife also cannot enter into certain agreements without the consent or the permission of her husband. And what I've done in this slide is I have listed the types of agreements that a husband or a wife needs permission before they can enter into that agreement. For example, any spouse cannot sell, mortgage any immovable property of the joint estate. Immovable property could be the house, the land. So the husband cannot decide on his own to sell the land or the house without the permission of the wife. The same applies for all the other assets that I've listed: pledging of shares, selling of jewelry that is held as an investment. Also, the husband or the wife cannot enter into a loan agreement with the bank without the permission of the other spouse. So as you can see, when you are married in community of property, the assets of both spouses come and form one joint estate and belong equally to both the husband and the wife. And that means that any action that affects the estate must be approved by both the husband and the wife. The wife cannot go outside and decide on behalf of the joint estate by herself, and the wife cannot go outside and do the same without her husband's permission in respect of the specific assets that I've listed here. I'm not going to go through all of it because of time constraints, but if you have any other questions, please do raise them and we will address them at the end. In the event, yeah.
Sorry, yes? Before you do proceed, can you please just have a look at the chat?
Okay. Is there, I just need to stop sharing. Oh, okay. My screen on presentation mode. How do we do that, Lucy?
Sorry, you just need to put your PowerPoint on presentation or slideshow mode.
Okay.
Yeah.
I see slideshow.
And then you can just put it on presentation. Or
how's that?
Yes, perfect.
Okay, cool. Okay. Where were we? Okay, so in the previous slide, I had stated that there are certain transactions that a husband and wife cannot do without the permission of the other. However, you will find that there are certain instances whereby either the husband or the wife withholds their permission unreasonably so. So you found a piece of land that is going at a very affordable rate, at a very with low monthly installments, low interest rates, and it's a perfect opportunity in an ideal area, and the property market is developing. You know, there's all these good reasons why buying this land is a good investment and is a good decision. And then you approach your wife and you say, my wife, I want to buy this piece of land. And for some reason, your wife says, I do not give you permission to buy this piece of land. Now, according to the law, you cannot buy this piece of land, but there's an exception. You can apply to the High Court for permission to buy that land, and the High Court will then grant you that permission. And once you have the permission of the High Court to buy that land, you will not require the permission of your wife. So these are in very rare circumstances whereby the husband and the wife are not seeing eye to eye with respect to the purchase or acquiring or selling of certain assets. It is also worth mentioning that there are certain assets that are excluded from the joint estate. That means that they remain and belong to whoever they belong to before the marriage. For example, if you got into a car accident, in South Africa, we have something called the Road Accident Fund. When you enter into a car accident and you've been injured, you institute a claim with the Road Accident Fund, they pay you maybe 400,000 Rand. That 400,000 Rand that you receive from the Road Accident Fund does not form part of the joint estate, and therefore your wife will not have a claim over that. So I'm going to move on to the second matrimonial regime. But before I start, I just want to know if there are any questions thus far with regards to marriages in community of property. Okay.
No.
No questions. Okay, good, cool. All right, marriage out of community of property. So the most common reason why people would elect to marry out of community of property is because they would want to protect their assets and financial position prior and during the marriage. A marriage out of community of property is a marriage that is concluded by signing an antenuptial contract. But you will see the abbreviation there is ANC. And when I talk about ANC, I'm not talking about the government, the leading party. I'm talking about antenuptial contract. So that's just a short abbreviation. So a marriage out of community of property, like I said, is achieved by drawing an antenuptial contract. The antenuptial contract will be the most important contract that the married couple will enter into in their lifetime. And the antenuptial contract will allow the husband and wife to tailor-make their matrimonial regime. So for example, in the antenuptial contract, the husband and wife can decide what assets are excluded, what assets are included, what obligations does the husband have on the wife in terms of assets, in terms of debts, in terms of liabilities. You literally design the consequences of your marriage, the financial consequences of your marriage. It's also worth mentioning that once you don't just draft an antenuptial contract, it needs to be registered. So you meet up with a lawyer who's called a notary, who will execute the contract, and then the contract will be signed by the husband, the wife, and the notary. Once it's been signed, it must be forwarded and submitted to the deeds office. Many of you who have bought houses will be familiar with the role of the deeds office. The deeds office holds a record of all property owners and title deeds. They also hold antenuptial contracts. And the antenuptial contract will take effect within 3 months of the date that it was registered. So now, when you're married out of community of property, there are 2 options that you need to choose and that you need to bear in mind. And please don't lose me because it kind of gets a bit tricky and complicated to understand and differentiate between the two. So if you need me to clarify something, please do stop me and I'm happy to do so. So the two options that you have is an antenuptial contract with an accrual and an antenuptial contract without an accrual. So what we're going to look at now is a marriage out of community of property with the accrual. And I will explain to you what it means. What do they mean by accrual? So as previously stated, when you marry out of community of property, each spouse will retain ownership of the assets acquired before and during the marriage. And the other spouse does not have any claim or rights to such assets. So if the husband has a car and a house that he had acquired during marriage, before the marriage, and during the marriage, he bought some assets. When he divorces his wife, he keeps all of that property and he does not need to share it with the wife. What we mean by accrual, an accrual is the extent to which the husband and the wife have become richer by the end of the marriage. What this means is that there is a comparison between the value of the assets each spouse had at the beginning of the marriage, and then you compare it against the value of the assets at the end of the marriage, and you calculate the difference. The increase or the decrease between the two is the accrual. So how do you calculate the accrual of the estate? So here, this slide will set out how we do so. So as I stated, it's the difference between the net value of the spouse's individual estate at the commencement of the marriage against the net value of the spouse's individual estate at the dissolution of the marriage. So for example, the husband's value of estate at the date of the wedding is 2 million rand. So at the date that he was married, he had assets worth 2 million rand. At the date of divorce, the husband's assets increased to 3 million rand. That means there was an accrual of 1 million rand in the husband's estate. Now we look at the wife. The value of the wife's estate at the date of the wedding was 1.5 million. At the date of divorce, the value of the wife's estate was 1.7 million. Therefore, the increase in the wife's estate was 200,000 rand. So you can see that between 1 million and 200,000, the husband's estate grew and increased more. And what happens when you married out of community with the accrual, it means the estate of the spouse with a lower accrual has a claim against the estate of the spouse with a higher accrual. Obviously, an accrual of 1 million is higher than an accrual of 200,000. So the wife will therefore have a claim over the estate of the husband. But how do you calculate that claim? Because the wife doesn't have a claim to the entire 1 million. There's a particular calculation, and this is discussed in this current slide. So you will recall, we have the 1 million increase in the husband's estate, 200,000 increase in the wife's estate. You have to deduct the two from each other. So 1 million minus 200,000 gives you 800,000. That 800,000, you then divide it by 2, gives you 400,000. Therefore, the wife is entitled to 400,000 from the husband's estate. Are there any questions around this calculation? Okay, I will take that as a no, and I will move on to my next slide. This is just an illustrative slide that I've made, again, just to drive the point and to really make it highlight exactly how it would look like. So we've got a couple here. We have Lindiwe and Oliver. At the date that Lindiwe and Oliver got married, they each had an estate of 100,000. During the marriage, Lindiwe's estate did not grow to anything. So she had nothing. But Oliver's estate grew by 500,000. So 500,000 minus 0 obviously is 500,000. And then what they do is that they take that 500,000, they then divide it by 2, which gives you 250,000. Therefore, Oliver must give Lindiwe 250,000 from his estate at the time of divorce. I'm quickly just going to mention that there are certain assets that do not form part of the estate, such as inheritance, legacies, and donations. So if before the marriage or during the marriage, the husband or the wife inherited a house, a car, or something from a relative, a father, a friend, whatever it is that they've inherited, that value of whatever they inherited does not form part of the estate and remains the property of the wife or the husband. I also want to highlight the fact that it is possible for a couple, for a spouse, to lose his right to claim against the wife. For example, if the marriage was for a short period of time, if the husband or the wife was an abusive spouse, if the husband or wife cheated during the marriage, then the innocent spouse can approach the court and say, look, I spent 10 years, 20 years building this company, building my life, and building my net worth. I just married this lady for 6 months. She cannot in 6 months claim half of my property, half of my belongings. Or the wife can go to the court and say, I married this man, we were together for 10 years, and he cheated on me for 5 years with multiple women. He cannot benefit from this joint estate. So he should forfeit his benefit. By forfeiting his benefit, you then claim his share of the benefit. But this is obviously subject to the court's discretion. And the court really needs to be convinced that there has been a serious case that warrants the forfeiture of assets. Now I'm going to move on to Lucy. I see there's another message in the chat box. What is that about?
Okay, so the question on the chat is basically asking how long is a short period when you talk about short period in terms of a divorce? Okay, so a short period, they look at a number of factors. They look at the age of the parties, because a short period between a couple that were married in their 50s is very different between a couple married in their 20s. So they look at the age of the couple, and they also look at the actual months. And if there isn't, for example, a limit whereby they say 2 years is a short period, 1 year. The legislation doesn't specifically state 1 year is a short period, 2 years is a short period, but you can always make the case. Ideally, in the most scenarios, people who are married for less than 2 years is a short period. In most divorce cases that we have seen, where couples have asked for forfeiture of assets, they've claimed that because I was married for 6 months, 8 months, 1 year, 2 years, especially if there were no children involved, that there is no reason why there should be a sharing of the estate. I don't know if that answers your questions. Okay, I think that should be fine for now. There is another question, but I think we'll save this one for a bit later. So we can get through. All right, cool. Yeah. Perfect. So now we're going to be discussing marriage out of community of property without the accrual. So just to remind you, the accrual, you will recall, is the increase on the value of the estate of each spouse, comparing it between the time of the marriage and the time of divorce. Now, when you marry out of community of property without accrual, you do not make that consideration. So what it means is that, in simple terms, there is no joining of spouses' estate into one joint estate. There is going to be 2 separate estates. So the husband will have his own estate, the wife will have her own estate. The husband can incur whatever debts he wants to incur, and the wife will never be liable for such debts. The same goes for the wife. The wife can incur any debts she wants to incur,
and she will not, and the husband will not be liable for any debts that she incurs. And at the end of the marriage, no spouse will have a claim under any circumstances against the estate of the other. So you will recall that under marriage in community of property, you get, each spouse has a claim of 50%. Under marriage out of community of property with the accrual, the financially weaker spouse has a claim of 50% of the increase in the joint estate. But without the accrual, there is no claim against any estate of either spouses. Whatever you came in with in the marriage is what you're going to leave with, either whether you're a husband or a wife. And this slide illustrates what the point I'm trying to raise. So we've got before the marriage, his and hers. You see that the blocks are the same. During marriage, his and hers, you see the increase. On termination of marriage, what he had during the marriage, he still has that. And what she had during the marriage, at the divorce, at the termination of marriage, is what she's going to live with. There is no claim on each other's assets. Each spouse retains what they had achieved before and after the marriage. I'm going to quickly, because of time, go through what are the different advantages and disadvantages of the different matrimonial property regimes. So we're going to start with out of community of property. So what are the advantages? Each spouse keeps their own assets and they're free to decide what they do with the assets. You'll remember that when you're married in community of property and have a joint estate, you are not free, you're not entirely free to deal with the assets as you please, because there's certain transactions that require to have the permission of your husband or your spouse. When you're married out of community of property, you don't require those permissions. You can sell the car with you, whether you want to or not. You can buy the land, whether your husband or wife is upset, they can't stop you, they can't block you, you can enter into those valid agreements. Another advantage is if your husband runs into debt because he got a loan to start a business, if he's not able to pay the loan, the bank will not go after the wife and vice versa. Another positive effect is but this is only for if you're a financially stronger spouse. So if you're the wife and you have more money, then the benefit is that you don't need to share any of that with your husband upon divorce, unless you're married out of community of property with the accrual. Let us not forget the accrual. The disadvantages of marriage out of community of property is obviously that if you are the economically or financially weaker spouse, you will not have a claim against the estate of the stronger financially stronger spouse. And traditionally, as we know, women have been the economically weaker spouse. This is more in a traditional sense, and there are a lot of instances whereby women in family households are earning more than their husbands. But traditionally, women are financially weaker, especially if they are housewives and they dedicated the time to contributing to the running of the household and were not able to actually make an income. And so if she's not able to claim from her husband's estate, that means she really leaves the marriage with absolutely nothing. So that's the very unfortunate part of it. So once again, it's this as if you're going to be a housewife or a house husband and you're not going to be earning any type of income, a marriage out of community of property would not be the best option for you. It is best suitable for people who are equally financially strong, have businesses going on, earning salaries, have assets, have shares that are at risk of being taken away because of a spouse's bad decisions. Those are the people who should ideally go for a marriage out of community of property. I am mindful of the time. I've got about 5 minutes, so we're almost there. Quickly, we're going to look at the advantages and disadvantages of a marriage in community of property. This is a marriage, you will recall, whereby the husband and the wife share everything 50%. There is one joint estate. So the clear advantage here is that there's no upfront legal costs. You will recall that in order to enter into a marriage out of community of property, you need to sign an antenuptial contract. The antenuptial contract is not cheap. It is quite expensive. The public notary public that drafts the agreement charges quite a lot of money. So when you're married in community of property, you don't have to draft the contract, so you save those costs. And I think the other advantage is more of a principle or a value-based advantage, in the sense that both parties are effectively working together for the benefit of the joint estate. So the husband or the wife is working very hard to make sure that the estate grows for the benefit of each other. The disadvantages of marriage in community of property is that couples will remain jointly liable for each other's debts. I should mention that this includes debts that were incurred before the marriage. So if the wife had a clothing account or had bought a car on credit before the wedding, and then she gets married and she's unable to pay the car or the clothing account that she had incurred before the wedding, the husband will be liable to pay off the car or the clothing account, and vice versa for the spouse, for the husband with the wife. If the husband incurred any debt prior to getting married, if he can't pay during the marriage, the wife will be, the bank or the creditor can go after the wife to claim payment. Also, another slight comment I would like to make here is that the management of a joint estate can be a bit burdensome and cumbersome, because they are, as we've stated earlier on, there are certain transactions that require approval from either spouses. Okay, I just want to also mention that there's something called post-nuptial agreement. So remember we said antenuptial agreement. Antenuptial means the contract is signed before the wedding. Post-nuptial agreement means that the contract is signed after the wedding. So what happens is that there are certain instances whereby a couple might find that actually we were married in community of property, but because of the different businesses we're entering into, the different loans we're acquiring, there's risks that we could expose ourselves to. So it's better to change our matrimonial property regime from one of in to out of community of property. The Act allows you to do so, and you can apply to the court. I do need to mention that it is an expensive application. So that's why it's very important for couples right at the beginning to decide which matrimonial property regime they want to choose. When the court decides, they will look at certain factors as to why you want to change. They will determine if there's sound reasons, if you've provided sufficient notice to your creditors, and that no other person will be prejudiced by the proposed change in the matrimonial property regime. Okay, in conclusion, it is important to reiterate that it is of paramount importance that both parties to the marriage understand the implications and consequences of the type of matrimonial property regime they are entering into. Unfortunately, couples focus so much on the big day that they disregard the implications of neglecting a well-informed decision regarding the regime that will inevitably govern their marriage. It is important to bear in mind that should you get married in community of property and later decide to change your matrimonial property regime to out of community of property, you can do so by applying at High Court, but this is both expensive and the change is not guaranteed. We've reached the conclusion of my presentation. I would like to thank you for listening, and I will be handing over to the moderator who will be assisting me with the list of questions that have been posed, and I will be answering those questions. Thank you very much for your time.
Thank you so much for that insightful information, Caleb. So we're going to start with the questions that have come up on the chat. And the first one that we got earlier that I'm going to go back to is, are donations from a spouse during the marriage considered to be excluded?
Yes. Yes. So if you gifts, birthday gifts, for example, you get elaborate couples who buy each other cars, diamond, jewelry, houses. If you divorce, your husband or wife cannot have a claim. So the husband can't say, okay, now we're separating, give me back the car I bought you, or I want half of the value of the jewelry I bought you. He can't do that, or she can't do that. It remains the separate estate of the wife or the husband and is excluded from the joint estate.
Okay, that's great. And I hope that answered the question. So you just mentioned a moment ago that there is a possibility for a couple to choose to change their marital regime.
Yes.
So what we have here is basically, if you've been married over 10 years, is there still a way, or is there a specific time frame that they give within which a couple can change the matrimonial regime?
There is no time frame within which you can change your matrimonial regime. You can change it within 2 years of marriage, 5, 10, even 50 years of marriage. If the circumstances warrant a change in matrimonial regime, then you apply to the court. Like I previously stated, the application is quite expensive and it's not guaranteed. So just because you're applying to the court doesn't mean that the court's going to grant you. And I'll explain why. Because each matrimonial property regime that you choose has a consequence. You will recall that when you're married in community of property, if you have lots of debts and you owe the bank or another creditor so much money, and now you decide that actually, let's get married out of community of property. What it means is that the banks will not be able to claim against your other spouse. So they are going to be affected. And the court is going to consider that and wonder, okay, who's going to be affected when you change the matrimonial property regime? And if someone's going to be negatively affected, there's a high chance that they are going to disregard and reject the application. So it's definitely very important to decide right at the beginning what kind of matrimonial property regime you want, but it doesn't stop you from changing it at the end. It's just that you need to there are specific considerations that the court is going to look into, and they are going to consider your reasons for changing, and they're going to consider especially who's going to be affected. In most cases, it's creditors, because most people change it because they realize they owe money and they're trying to save the house. Because if the house is in the wife's name, but the husband owes the debt, the bank won't be able to go after the house. I think that makes sense.
Okay, yes, it does make quite a lot of sense. So the next question we have here is married out of community of property without accrual. If there's a divorce with kids involved and the wife has custody of the kids, can she use the kids to claim from from her spouse?
Yes, indeed. She can't, not in that sense, like use the kids to claim, but what she can claim is spousal support, and what she can also claim is child support. So spousal and child support is not affected by she can only claim spousal support if they were married in community of property. She cannot claim spousal support if they were married out of community of property. But if they have children, she can always claim for child support, irrespective of what regime they've chosen, whether it's in community, out of community with accrual. The husband or the wife has a duty to take care of those children, and they cannot negate that duty by choosing a specific matrimonial property regime.
Okay. All right. So the next question, I hope I do bring the question across correctly, basically says, if as a single person, you have some assets, can you protect them when you're married if you want to enter in community of property?
No. Unless those assets are part of unless the asset is an inheritance. So for example, if you inherited your dad's car before you got married, that will be excluded. If you received a donation from an organization or a prize for winning a competition or whatnot, that will not form part of the joint estate. But if you bought a house or a car, whatever asset that you bought when you were single, if you enter into a joint estate, you cannot exclude it. The only way you can do so is by entering into an antenuptial contract. So what I'm basically trying to say is that if you get into, if you find yourself in a situation whereby as both of you as fiancés before the marriage are writing on a piece of paper saying, this asset is mine, that asset is yours, this asset is mine, that asset is yours, this asset is mine, that agreement will not be valid unless there's an antenuptial contract that has been signed and registered with the deeds office. In the absence of an antenuptial contract, the spouse will have the claim for 50% of that estate, unless, like I said, it's inheritance, a legacy, or a donation.
Okay, that is quite a tricky one.
Yeah, that's why it's very important. Yeah, that's why it's very important right at the beginning to decide, and it's important to consider thoroughly, what am I worth? What are my assets? What am I bringing to the marriage? And am I at risk of losing it? For example, maybe your partner is involved in high risk investments that require loans, or is invested in a business that requires debt, but the chances of the business surviving are very slim. A lot of considerations. Yeah.
Okay, that's very interesting to know, especially for a lot of us who aren't married yet, just knowing how to plan ahead for the future, knowing that we want to go into investments and things like that. And the one question that we do have, I think, is one that's on a lot of people's minds. When you say expensive, do you have any figures or an idea of, the price range within which one can expect to find themselves should they choose to go into a marriage out of community of property or change into one?
The costs that would be incurred in entering into a marriage out of community of property.
Absolutely.
I can't put a specific figure on it, but what it will also determine on the type of lawyer you're going to see. So lawyers, we sell time. So each time we spend drafting the antenuptial contract would come up to the bill. So for example, if I charge 800 Rand per hour, and you come to me to draft an antenuptial contract for you, I'm going to charge all the hours that I spent drafting, all the hours that I spent consulting with you, all the hours I spent signing and sending the agreements to the deeds office for it to be registered. I will charge for all of that. Or that public notary will charge for all of that. So it really depends on the seniority of the lawyer. So if you go, for example, to a public notary that's based in Sandton at one of the biggest firms, you best believe you're going to be paying at least 5,000 Rand per hour. Versus if you go to a smaller, medium-sized firm where the public notary is based maybe in Johannesburg or even like Melville, he's most likely going to charge you 2,000, 1,000 Rand an hour. Also, you can also agree on a fee cap with your client, with your lawyer. So you might say, okay, I need you to draft this agreement for me, but I only have 20,000 Rand. So you can only make sure you manage your time so that you only rake up 20 hours or 5 hours, but however hours you do should not exceed the fee cap of 20,000 Rand. It is practice for clients to be very open and frank about their budget, and lawyers are always willing to negotiate on fee caps and open to stick to fee caps and work in accordance to a fee cap. You're just on mute, Lucy.
I was saying that's very interesting. My pocket hurts just thinking about it, but I can completely understand that. I guess a lot of work goes into it, a lot of research and getting the right information and all of that. And the next question that we have is, does alimony still apply in out of community of property regime?
So alimony is, I'm assuming, spousal support. Spousal support does not apply out of community or property.
So whether it's with or without accrual, it does not apply?
No, it doesn't apply.
Okay. All right. And the next question says, do all these agreements only come into effect if one of the spouses either passes away or they decide to divorce? In the latter case, is a divorce certificate the only document that will be accepted as an official trigger for any of the agreements to come into effect?
Okay. These agreements come into effect from, okay, so the antenatal contract will come into effect from the moment 3 months after being registered at the deeds office. So it's, by it coming to effect, it means it's a valid contract and it's there. And then the consequences of that contract then occur obviously at a later stage. So the contract during the marriage comes into effect within 3 months of registration, and then the consequences will then manifest at either the earlier of divorce or death. So if it's whichever occurs first, then the consequences manifest. And then the other part of the question was whether the divorce certificate is the only document that will be accepted as an official trigger. The court judgment, yes, the court judgment will be the official document that would need to be presented in order for the consequences to materialize. So for example, if you are married out of community with accrual, and now you want to claim half of the accrual in the estate, you would need the marriage certificate confirming the order, the divorce order, and with that marriage certificate, divorce order confirming that the parties are divorced. Once you have that, you are entitled to then claim if you are the weaker spouse, obviously entitled to then claim the 50% of the accrual.
Okay. And now on to our next question, which I'm loving because I'm sure it's on a lot of people's minds. Can you maybe donate your property, for example, or get it registered under a child born before marriage so that it does not enter in the joint estate?
True, you can. A lot of people have found loopholes, and this is a loophole. And so if you have a child born before marriage, you can always register the property in their name, or you can form a trust and make them the beneficiary of the trust, and you donate the assets to that trust. And then the child being the beneficiary of the trust is obviously the owner of the property. In that instance, the property will not form part of the joint estate. So that's a loophole that some people use in order to protect certain assets from being taken or divided once the marriage is dissolved, or if for example the bank wants to go after the couple. They're not divorced, but they owe the bank so much money. So the bank is looking at, okay, what do you guys both own? They will not look at what is under the child's name.
Okay, that's a very interesting one. But now say in the event that you are married and as a couple you do purchase property and put it under the children's name while you're married, does that principle still count?
Yes, that principle still applies. It's the property of the child. It's not the property of the husband or the wife. It doesn't matter that they paid for the property. What it matters is who is the rightful beneficial owner. And if the beneficial owner is the child, then unfortunately for the banks, they will not be able to access that property and lay claim on it.
All right. Okay, so this question says, in community of property, you mentioned that the spouse needs the permission of the other spouse before getting loans from the bank. Does this apply to personal loans as well?
Yes, it does. And I'll tell you why, because when a husband or wife enters into an agreement for a personal loan for their own needs, or for maybe their own business, when he's not able to pay for that loan, the bank is going to go after the wife. So the wife must consent to the risk that, honey, if you can't pay off this loan, I am very well aware that they'll come after me. So that's why you need her consent or his consent, because she will be affected by your decision. Because getting a personal loan doesn't mean that the banks will only go after you. If you're married in community of property and you have a personal loan and you can't pay, best believe the bank will then go after your wife or your husband. And that's why their consent is necessary, because they might say that this personal loan is too risky. We don't have the financial means to pay it off. There's a risk that you won't be able to pay it off, then I'll have to pay it, and I don't want to take that risk. And that's why they need to give their consent.
All right. So the next question is wanting to know, as opposed to an unofficial separation where they have not divorced, but are just separated. I think this one is linked to the question we had about the agreement and when they come into effect. So in terms of, so previously, this person had asked about when an agreement, you know, the antenuptial agreements are signed, do they come into effect, you know, as they're signed or afterwards? You mentioned something about 3 months. So I think this question might be linked to the whole divorce and death.
All right, so in this instance, you're basically married out of community of property. You've signed the antenuptial contract. The antenuptial contract, within 3 months of being registered, becomes into effect. And then 2-3 years down the line, the couple decides to separate, but they don't divorce, and they don't apply to court for a divorce order. If that happens, that means they are not divorced by a court of law, and that they're still legally married, even though they don't stay together. Because in South Africa, in order for a divorce to be valid and effect, and for the consequences to follow, there needs to be a divorce order granted by the court. If the couples decide together that, look, we're not happy with each other, we're going to separate, but for some reason do not proceed to apply for divorce, then they are still considered married. And the reason why it's very important is because the husband or the wife who are living separately will not be able to enter into another marriage because they're still in a particular marriage. Obviously, there's customary laws that allow for certain men to enter into polygamous marriages and, you know, to separate from the wife without divorcing and get other wives. But if you're not married according to customary laws, and your marriage is not a customary marriage, but rather a civil marriage where it's been registered with the courts, the only way you can separate and for consequences of the separation to come into effect is to apply for a court order. So an unofficial separation does not trigger any consequences.
Okay, thank you very much for that. So this question is almost similar to the one I posed earlier with regards to the property issue, but this one is more on, can you donate the property to an unborn child born of the marriage?
The tricky thing is, when you need to register the property, you need to give a name and an ID number and some sort of recognition. So if there's an unborn child, you know, really, you will not be able to effect registration, and you'll not be able to claim, because when we go to the system, they'll be like, who's the owner? Okay, the owner is, you want to name this child Samantha Jones. The owner is Samantha Jones. Okay, we go to the system. We don't even know who Samantha Jones is. She doesn't exist. So there is no owner. So you would rather maybe donate the property and put it into a trust and make somebody else, like a sibling or your mom or your dad, a beneficiary of that trust. And then when you have children, you just simply remove your parents as beneficiaries and replace them as your children. But you can't make someone a beneficiary if they didn't exist. However, in a will, what people typically say in a will is that, you know, I share, I want all the children born out of this marriage to share 20% equally onto this, to inherit 20% each. But when you did that will, there were no children. But once they are children, then they automatically would inherit. So that's a different story. But in terms of protecting property, you can't do it by donating it to an unborn child.
Okay. We have a question here that says, is there costs involved? I think this goes back to the need for a spouse to get permission from their respective spouse to get a loan from the bank, for example.
There aren't any costs. Okay, there aren't any costs with getting permission from your spouse. That's just something that you just agree together, and you can either write it on a piece of paper or type it together as some sort of proof that there was consent. The only costs involved in terms of deciding a matrimonial property regime is if you're going to do an antenuptial contract, and like I said, the cost of the lawyer who's a public notary and the cost of registering the antenuptial contract. But other than that, there aren't any costs, other than obviously the typical household costs of the upkeep of the house, food, clothes, water, electricity, the typical costs that you would incur irrespective of what marital regime you choose.
All right, thank you very much for that. And I just like to apologize to everyone. We might run a little over time. We just want to get through all the questions. So we might take an extra 10 to 15 minutes, if that's okay with everyone, just to get through the last few questions.
Okay.
Okay, so in line with the question I just asked now with regards to the consent from the one spouse and all, is there a specific type of proof that one needs to bring, like a document signed by the other spouse? Do they need to bring the other spouse? How does it work in the event of getting a loan or signing for something?
So for the transactions that require the spouse's consent, it depends on what assets is being acquired or sold, and as well as the value and how contestable it could be. So if, for example, the asset is a house, the bank will require a formal written consent of the wife. So the bank will require the wife to actually sign on the bond to confirm that she consents. So it honestly depends on what asset there is, and different industries or companies or banks will have different requirements. Some banks will say, okay, you can get a personal loan. We don't need your wife's express consent. We are assuming that she's already given consent. Or there are certain agreements whereby they specifically want you to warrant and say that I, Mr. What, have asked permission for my wife and my wife said yes. You know, it becomes tricky if the husband lies and claims the wife says yes, even though she didn't. If it comes to a point whereby it becomes contestable, the wife can show proof that she had no idea about, if she's able to prove, she can show that I had no idea that this loan was actually taken. I did not give consent. And in those circumstances, which are very rare, the court might say that the wife did not consent. So there is no way she can be held liable for your actions because you didn't do what you were supposed to do.
All right, that is, so people need to definitely think twice before going and taking loans without their spouses and the consequences follow. Okay, so this next one, so let's say you want to enter the real estate business, both you and your spouse. Which regime would you recommend for that?
Okay, it depends. If you're entering into the real estate business by credit, it would be based out of community of property with accrual. But if both spouses have cash and there are no risks involved, cash doesn't carry any risks. So if you're lucky enough to be buying these properties cash, by all means you can choose going into a marriage in community of property, because now there isn't a risk of if the bank if you owe the bank money that they're going to claim the house. And another thing also, if you're married out of community of property, but both spouses want to enter into a marriage, no, but you're married out of community of property and both spouses want to enter into the real estate business. Another way of protecting it is the husband gets the loan to buy the house, but then the house is registered in the name of the wife. When the husband can't pay his loan, the bank can't go after the house because the house belongs to somebody else.
We're learning tricks here today.
Yes, that's only if the husband is unable to pay his debts.
Okay,
yeah.
That makes sense. Okay, so this next one, I'm sure this one is going to be a pretty good one because we do have circumstances, especially in our community where
silver and precious stones. Is it why you do what you do, and then you get a reward from the Lord.
Okay, sorry about that. So yeah, we do have a lot of cases, I can specifically say, in our community where a lot of couples are married traditionally, but not, not married in the court. So this question is basically, I once did my nails at a lady who had just lost her partner of 10 years. However, they were never officially married. At his passing, she was not able to gain anything. Does the court consider specific circumstances, or is it strictly based on marriage?
Okay, so there've been a lot of cases like this before South African courts, whereby the couple did not have a court wedding, and they weren't married before a civil court. However, the court looks at circumstances as well. Civil unions and civil partnerships are recognized. A civil partnership is where a man and a woman live as a married couple for 10 years, 15 years, they have children. They just never went and signed and got a marriage certificate. The court will consider that and say, no, but these two lived as a married couple. They were responsible for each other. They contributed towards a household. They have children and they supported each other. In that circumstance, when she can prove that, she should be able to claim. I think in this situation, there was an unfortunate situation in the sense that she probably either did not get good advice or she was not able to afford legal advice to be able to fight for those assets.
Okay. All right, so that one is that. And the last question that we do have is that you are talking of bank risks. What about tax risks? So in terms of SARS and those consequences?
Yes, equally so. If you owe SARS money, if you haven't been paying your taxes, SARS can attach your property to recover the money that's owed to them. If you're married in community of property, SARS can attach the property in the joint estate. So the risks are equally similar to banks and loans from the banks. So if you're married out of community of property and it's without accrual, for example, and you owe SARS lots of money as the husband, SARS cannot go after the wife. But if you're married in community of property, the husband owes money, there's assets in the state which belong to the wife, SARS will have a claim on those assets by virtue of the fact that you're married in community of property and that asset forms part of the one single joint estate.
Okay. So I think that's all the questions we had on the chat. I'm just going to open up for everybody that is currently on the meeting. Is there anybody that's got a question that they'd like to ask Caleb directly, or are we fine for now? Okay.
It looks like we're fine.
Okay, looks like we don't have any questions from anybody else. So with that,
may I make one comment? Sorry about that. Hello?
Yes, yes.
Hello, yes, you can go ahead.
Yeah. What I want to say is, I think just so from experiences, what should be more for us to pay attention is not to base our love on material, but to have that love of protecting one another, especially if you are going into business. It will be good for you to protect your spouse and your family. Like Caleb said, you borrow the money for the business or for the property, but you put the property under your wife's name. And the wife needs to understand as well that we're doing this for the family, for the children, for the future, not to take advantage of the situation that now the property is mine, I don't owe anything, that's his problem to pay, I'm going. So I think we need to promote love of your family, the future for your family when you're entering into agreements, not to put material first, but to put love first. Thank you.
Yeah, and just to add on to that, Papa Eddie, a lot of people, growing up, they would say, like, if you're choosing a marriage out of community of property, that means you don't love me, or that means you're thinking we're going to divorce. But in the truest sense of it, it's just one recognizing the risks that are involved in terms of the assets that they have, in terms of the financial obligations that they have, and honestly, it's about that protecting either themselves or the partner from the risk of losing the assets that have acquired. And you will understand that a lot of marriages fall apart because of money and because of assets being taken away, because of these irresponsible decisions or just decisions that have happened. For example, COVID-19, a lot of couples maybe, for example, had invested in certain businesses that, for example, tourism, and now you're not making any income, and that you have loans that you have to pay, and now eventually the bank starts going after the property of the other spouse, and that starts causing tension and problems in the marriage. So it's really, it requires, when you're choosing a marital property regime, to decide, what are my assets? What line of business am I in? What are the risks that I could potentially be exposed to? And how do I protect everyone so that I make sure that my household is succinct if anything was to go wrong? And we need to think like that. We need to think worst case scenario. Yes, we want, you know, to be married forever. Yes, we want nothing to go wrong. But the reality of we cannot control those factors. And we need to think of those and take that into account.
That is absolutely true. And I feel it's great that these are conversations that we are now having as a community. And I've seen quite a lot of the comments in the chat thanking you for this very informative session. I know that previously we have had this chat as a group of friends, and you know, it's always good to learn these things and to have, you know, our parents who've been married for years hearing this information, you know, learning something new and how best to direct things. So with that being said, I just want to say thank you so much for this evening, Caleb, for the information that you've shared, all the knowledge that you've imparted on every single one of us. I'd just now like to hand over to Papa Marc for closure, and then we will call it an evening.
Thank you so much for having me.
Thank you so much. Caleb, be ready to come back, because as you can see, there were so many questions.
Yes.
And probably the many people that missed will come back and ask questions. This session is live on YouTube, and we will have it arranged to be on Facebook and on the website. But I'm sure you'll come back for the live session, because a lot more people will ask questions and will be interested. I should thank you so much for sharing your skill, your knowledge in such a short time. We really learned a lot. And thank you in the name of CoopCongo, which is trying to enable the sharing of knowledge in the community. And for the brilliant moderation, thank you, Lucy Njeka, for the brilliant work. So today it was quite a brilliant team of young people teaching us. We are in the 50s, 60s, and 70s, but we quite learned. So thank you. You should continue in that way. And to close, we hope that you'll come next Thursday for another CoopCongo session every Thursday at 7, from 7 to 8. This is for us to learn about finances as we trying to build the bank, the future bank for Congolese people in Southern Africa and the world. Next week, as you've seen, we had a survey on how we handling our finances in the community. So the team that has been running that survey will give the feedback of what they discovered in the community. So please come back, and we will share next week with another brilliant session with the young people in the community sharing their knowledge. Thanks a lot, everybody, and God bless you all. We thank CoopCongo team. Thanks, bye.
Thank you, bye everyone.
Thank you, bye everyone.